Good afternoon, everyone. Today we are going to start the topic of international law, and today we are going to discuss about we are going to define international law, we are going to discuss about the main features, and we are going to basically outline all the other modules that are related to the international law. The learning objectives related to the international law in the current syllabus include the learning objective G4, G5, and G6. Okay, so today we are only going to outline the international law system. We're going to speak about the features of international law. We're going to speak about some historical developments in international law, and we are also going to briefly outline the theoretical perspectives on the international law system. So basically, in your future essays, if you're going to have any topics related to international law, you must be able to at least analyze it from the perspective of one international relations theory. Okay. Then we are also going to, in our further lessons, we are going to discuss a learning objective D5, which is going to where we are going to try and analyze whether whether we are talking about international law and from the perspective of a system which allows the states to communicate with each other and keep the relations on interstate level, or we are moving towards a global governance where we have the non-state actors that are interfering that have played a major role in international law system, or we're talking about a global law which basically explains the relations on a global level. Okay, and then we are also going to return back to the humanitarian law, and we are going to try and use those case studies we took in module C in first semester, and discuss the laws of war and and relate them to maybe similar case studies, or we are going to choose some different case studies and try to explain whether the laws of war, the laws of war, the types of laws of war, and how they have been affected by the recent wars. Find lots of information, a lot of information by accessing the following slides. So the main source is going to be Globalization of World Politics, chapter 19, page 301, 315. You also have the soft copy of Joshua Goldstein's book, International Relations, and you can find information in chapter 7, International Organization Law and Human Rights. So and of course you can study from these slides. For those who are interested in going an extra mile, you have Malcolm Shaw, International Law, have Introduction to International Law by Robert Beckman and Dagmar Butte. You also have International Law Collection of Instruments, International Law as a Language of International Relations, and then you have Jeremy Waldron, Rules of International Law. So all these things are available online. You can, if you wish to study more about international law, you can access them all. So let's proceed with our lecture. Furthermore, we are going to discuss about international law. There are multiple definitions of the international law. Conway Henderson states that international law is the collection of rules and norms that states and other actors feel an obligation to obey in their mutual relations and commonly do obey. So you can use this definition of international law, or else you can find a valid definition in any other sources I have recommended you in my previous slide. Well, there are three different branches, I would say so, of international law, or three different directions on international law. So we have the humanitarian law, which applies to the wartime, or and it's regulated by Geneva Conventions and Hague Conventions. And then we have the other matters that would include most of the regulations related to rules for international organizations, rules for diplomatic relations, civil aviation, rules or laws on sea or territorial apartments. Then we have the human rights. This type of this particular laws, or let's say this particular category of international law applies to the peacetime. Okay, so you can classify the you can classify them in 6 global core conventions, right? Civil and political rights, economic, social, and cultural rights, rights against racial discrimination, rights of women, rights against torture, and rights of the child. Okay, so basically we are going to discuss both humanitarian law and human rights in our next learning objectives, and let's see now how exactly international law has developed. Now, of course, similar to what we have discussed before, or similar to other topics we have discussed before, the theories of IR also refer to the international law. I briefly selected the, we'll say, the main ideas here in this slide. You can have a full picture to the theoretical approaches to international law on page 311, 313 of Globalization of World Politics. Okay, so basically international law is going to have a different interpretation from the perspective of different theoretical approaches. So realists argue that international law is only important when it serves the interest of powerful states. Neoliberals are going to focus on how self-interested states can come to construct dense networks of international legal systems. If you remember, we have discussed about the importance of institutions for liberals, right? And we also said that neoliberals said that the state national interest is going to be important, so this is where they agree with the realists, and at the same time the states are going to create a network of international institutions and legal systems in order to control, in order to maintain the order and balance of power in world politics. Constructivism will focus on the normative structures. So if you still remember from the first semester, we discussed about the idea that constructivism focuses on norms and values. Okay, and we are going to emphasize, constructivism is going to emphasize the way in which the law, like any other social norm, is going to contribute to the identities, interests, and strategies of the actors. Okay, so constructivism is mainly going to focus on the domestic level of analysis. Now, the critical theories are going to concentrate on the way in which the inherent liberalism of international law seriously, basically, undermines the radical potential, and the practice theories are going to I'm going to say that the state or legal obligations derive from coercion and consent or legitimacy, and they're claiming that the international law is a product of participating in the practice of it. Okay, so you can read more about it on page 311, 313. Those who are going to write their courseworks on topic 3, you'll have to use theory, so you might refer to this particular pages. Now, We have discussed about institutions, and this is where most of the confusions come in place. When we are discussing institutions, we don't only refer to institutions as organization, okay? Institutions in international law are going to be those constitutive acts or norms which were created in order to or were elaborated to maintain the balance of power. So we have constitutional institutions, which basically include the constitutions of the states, and this include the primary rules and laws of international society. It's normally recognized. Normally, in this particular institution includes the norm of sovereignty, which basically holds that within the state, power of authority are centralized and hierarchical. Okay, and outside the state, there is no higher authority that exists. So this is we can say that this particular statement belongs to the realist approach, right? So the constitutional institution is going to refer mostly to the constitutions of the states, and is going to include the concepts regarding the sovereignty of a state. The fundamental institutions are based on the foundation by constitutional institutions. So this is basically the next level of international institutions, okay? They represent the basic norms and practices that sovereign states employ to communicate with each other, to cooperate with each other in conditions of international anarchy, okay? So the fundamental institutions have varied from one historical system of the states to another, but in modern international system, the institutional practices of the contractual international law and the multilateralism have been the most important. We are going to discuss multilateralism later, and we are going to refer to the Westphalian system, which we basically discussed in the first semester before. And then we have issue-specific institutions, or we have issue-specific regimes, okay? These are sets of rules and norms which involve basically a certain domain of international life, right? So basically, in our previous module, we discussed about the weapons of mass destruction, and then we discussed about non-proliferation treaty, right? So this is a issue-specific institution. The non-proliferation treaty is a treaty signed to basically to limit the weapons of mass destruction, the use of weapons of mass destruction, the creation, any type of tests on weapons of mass destruction, and so on. Okay. Another issue-specific institutions could be the Framework Convention on Global Climate Change, Ottawa Convention, Anti-Personnel Landmines, and so on. Okay. The issue-specific institutions or regimes are concrete enactments in specific issue areas. So you don't have to mix them up with the fundamental institutions. Like fundamental institutions would be like Charter of United Nations, right? A constitutional institution would be the Constitution of Qatar, for example. Okay. Now, so if we are going to connect the international institutions to international organizations, we can say that the institutions cannot exist without an organizational dimensions, and the organizations cannot exist without an institutional framework. What does it mean? It means that basically none of the intergovernmental organizations could actually exist without an international institution. It would not be able to exist without norms and regulations which would coordinate their actions, as well as the institutions cannot exist actually without organizations, right? So in a way or another, the states are trying to cooperate. Whether they have, if we're talking about a pre-World War I period, the states were still trying to collaborate. They were creating antagonist alliances against each other. So this is also a form of cooperation. But they were not actually creating organizations that would ensure that cooperation. They were mostly trying to put the power as the major, or the power and the capabilities is the major way to exercise their influence. Okay. Now, the modern international law is basically a historical artifact. Okay, and it is a consequence of the Treaty of Westphalia, right? But the modern international law, or the basis of modern international law, was put during the French Revolution. Okay. So basically, the main distinctions of the modern institutions of international law are the multilateral form of legislation. The modern international law is a consent-based form of legal obligation. It is also language and practice of justification, and it's a discourse of institutional anatomy. So we are going to discuss it one by one. On the other hand, in order to discuss about the institution of international law, we have to understand key constitutive legal treaties which basically stay at the core of the modern international law. The first one is the Treaty of Westphalia. Basically, this treaty ended the 30 Years' War, and it was crucial in establishing the political rights and authority of European monarchies, and it allowed the monarchs to maintain standing armies and to include taxes, build fortifications, and so on. A little bit later, in 1713, the Treaty of Utrecht actually would put a basis of the territorial sovereignty in Europe. Okay, so the Treaty of Westphalia was just the first step, right? So the Treaty of Utrecht basically established fixed territorial boundaries, and it removed the idea that the territories belong to certain families. So basically, the treaties of Utrecht established the present link between the sovereign authority and the territorial boundaries. So basically, when we discussed about the state as a political entity, we said that two of the main characteristics of the state are the territoriality and the sovereignty, right? So the principle of territoriality and sovereignty were established in the treaties of Westphalia and Treaty of Utrecht. Okay. So basically, 100 years later, European states would sign the Treaty of Paris. Okay, in 1814. And this treaty contributed to the end of the Napoleonic Wars. We discussed about it briefly in the first semester. And it also established, like, it was the first step towards the post-Napoleonic War settlement, right? And it also established the rules or rules of behavior of the states after the Napoleonic Wars. It stayed at the core actually of the further scramble of Africa and so on. Okay. Okay, so the Treaty of Versailles was signed after 1919, and it contributed to the end of World War I. It established the League of Nations, it specified the rights and obligations of the victorious and defeated powers, and created mandatory system under which basically the Western nations were given a legal to they were given a mandate over the colonial people, right? So we discussed this in Module C. If you return back to your study guide for the Module C, you're going to actually find this information there. Another treaty or another document or another institutions that we discussed about before is the Charter of United Nations, signed in 1945. And this is a legal regime that created the United Nations as the world's only supranational organization. And it defined the structure of United Nations. It established the powers of constitutive agencies, so basically it established the main roles of the institutions of United Nations, like United Nations Security Council, General Assembly. It also established which countries actually have more power, like for example those 5 countries with power of veto in the United Nations Security Council. Right, the Charter is the key legal document which is limiting the use of force to it actually establishes the major principles of the collective peace. And we have discussed about the declarations of independence, granting independence to colonial countries and people in 1960. We discussed about it when we spoke about decolonization in Module B. And we can say that this is an issue-specific institution, yet it is very important because it basically established it basically led to the fact that the colonial system has collapsed, and new actors, new states appeared on the international system, and you can refer, and by actually analyzing these types of documents, you could spot certain maybe mistakes that were made during the decolonization process. Furthermore, there are many discussions behind the idea whether the international law is an expression of a Western dominance or not, right? So those who are supporting the idea that international law is part of the Western dominance believe that the international law is a result of the imperial of a Western imperial institution. Because it basically comes back from 16th, 17th century, when the majority of the legal or institutions were inspired from the Roman and Greek thought. Okay. So some scholars also are trying to imply that the international law is driven by the Christian thought and the way the Christians actually viewed people from Muslim world, Americans, and later Asia. Okay. Another version of the Western bias is found in the Standard of Civilization, whereby the European powers codified international law during the 19th century. So basically, some supports the idea that the international law actually is driven from the increased inequality and colonization, right? So basically, from this perspective, the non-Western political entities were granted a sovereign recognition only if they follow the certain domestic political characteristics, or only if they follow the Western type of political system. Okay, so from this perspective, European powers divided the world's people into civilized, barbarian, and savage societies, and this is how they justified it like how they justified that they controlled this particular territory. So many believe that the Western bias is still characteristic for the international legal order, right? And they are implying the idea of the Anglo-European dominance, right? And the way they actually impose their Western values, about individual rights or non-Western societies, for which this kind of ideas are actually not appropriate due to their cultural background or identity they have. So the Western powers are accused of using the privileged position in the Security Council, and basically adapting the human rights norms according to their own values, and use the human rights norms to intervene in the domestic politics of developing countries. So the modern international legal system is also set up on customary law norms, basically that support the legal equality of all of the states and their rights to self-determination. However, it's not really, or let's say this kind of norms are not really followed. And so far, the non-Western states are actually were the biggest supporters of the self-determination norms, and non-Western people were also involved in development of international human rights regime. And it basically nowadays, like, well, let's say the things changed, and nowadays the Universal Declaration of Human Rights, for example, and the Covenant of Political and Civil Rights was a product of a broader negotiation over how exactly this rights should be imposed. Now, furthermore, we are going to speak about the features of international law, and you can read more about the features of international law in Globalization of World Politics between the page 305 and 308. The main feature of international law, and this is what I suggest you using in your essays, is the multilateral legislation, consent and legal obligation, language and practice of justification, and the discourse of institutional autonomy. So we are going to discuss them briefly in the further slides, but you can actually read more about them in your So basically, the multilateral legislation is considered the principal mechanism modern states would use to legislate international law, and this is multilateral diplomacy. Okay, so multilateral diplomacy is defined as the cooperation among 3 or more states based on or with a view of formulating reciprocally binding rules of conduct. So if you're talking about multilateral legislation, you can relate this to the liberal concept of development of institutions, as well as the cooperation, and you could also employ here the idea of the ideas of cooperation and institutionalism, right? So we can say that the new norms and rules are actually evolving constantly, okay? And this development of the norms and rules are not only are not only related to the states, but they also imply the non-state actors, right? And there is actually a huge debate whether the new legal norms are evolving to qualify the state sovereignty and allow the humanitarian intervention, right? So basically, what does it mean? Is the state still a closed box, and a sovereign state would not allow any kind of intervention internally, or the state should step back, and in case if it is not able to protect citizens, it should allow the international community to sort out these issues. If this kind of norms are evolving, the scholars say that this process of multilateral legislation, it's not complete yet. Okay, then the informal processes in international law development are actually very important to take into consideration, because the international law is a customary law, right? And it is very important to make sure that they are followed by a majority or by all the states, and it doesn't matter whether they're consented or not. So basically, we're talking here about a movement towards a supranational law, right? And all the states should, in this case, all the states actually have to follow this legislation and have to agree with this legislation. Another feature of the institution of the international law is the consent and legal obligation. Okay, so this is a norm of modern international legal system in which the states are having the obligation to observe the legal rules because they have consented to those rules, and states that actually did not consent to the rules of a particular legal treaty are actually able to not follow them, right? The only exception to this concerns, and we discussed it in previous slides, is the customary international law. And in this case, the customary international law is actually implemented in a tacit way, which means that it is everyone has to follow it. Okay. So basically, there are two things that are complicating the status of consent as the main source of modern international legal obligation. So in order to determine whether the law is customary or not, the scholars actually look for a general observance of the norm. Okay. What does it mean? It means basically that the tacit consent is not the same thing as the actual consent. Okay. The idea of consent is the main source of international legal obligation. Okay, and it's the consent can only be something compulsory if there exists a prior rule that specifies and promises to observe legal rules and bindings. So because these rules would be what gives consent its normative standing, consent cannot be the source of that prior rule's obligatory force. So what does it mean? It means that basically the international law is still something that is developing. So it's very difficult to determine which treaties or which decisions by the international institutions have to be followed by the states, and from which they actually should be considered as customary laws, right? And which of them, for which actually the states have the right to say no, or have the right not to follow them, right? And this is the issue actually of the issue-specific institutions. So if you follow the news, you could see that, for example, Donald Trump, when he took the presidency, he actually refused to participate anymore in the peace conference treaty, agreement, right? Another feature of the international law or institution of the modern institution of international law is the language and practice of justification. Okay, so basically the modern international law is characterized by a distinctive form of argument, justification, and reasoning. And we can actually justify what is right and what is wrong. We can build legitimate, we can actually explain whether a certain action of a state or a non-state actor is legitimate or not by applying the rhetorical legal argument or the analogical legal argument. So if we are going to apply the international legal argument as a rhetorical one, we are going to deal with findings and interpretation of applicable norms and procedures for a certain case study, right? And we are going to try and look into the facts and their evaluation. So basically, you're going to take a treaty from international law, a treaty that is signed between certain parties, or a certain resolution that is given by the United Nations Security Council, and you're going to have a look of what exactly that particular treaty involves, right? And then you're going to apply to the facts of a certain situation, or a certain case study. Like, for example, were the actions of US legitimate in 2003 or not, right? So if you're going to take into consideration the resolution taken by the United Nations in that particular moment, you're going to actually try and see what exactly was acceptable in actions of US in that particular moment and what wasn't acceptable. Do we have to blame US that they actually they sent troops in 2003 to Iraq, or we have to give them a certain justification? Okay. Then, if we're talking about the international legal argument as an analogical one, this type of practice is concerned with establishment of the similarities among different cases or objects and the differences, right? And we can have we can reason the actions of the international actors in three different ways. We use them to interpret a given rule, right? So, for example, if we're talking about the again the 2003 US-led invasion to Iraq, so United Nations have taken a decision upon, they issued a resolution, right, so that there is no weapons of mass destruction, so there is no reason for them to send troops in there or to create a coalition, right? So we are going to have a look into the reasons behind why exactly US has actually interpreted the rule in different way, right? Then we can draw similarities between one class of action and another to claim that that basically if the actions were justified or not, right? And then we could invoke analogies to establish the status of one rule with reference to another rules, right? So basically, we could actually justify whether, for example, why US have, if US got involved in the war in Afghanistan in 2001, because they wanted to stop the insurgencies. Why they didn't get involved, for example, in Rwanda a little bit earlier, right? Or if, for example, why exactly, for example, US did not get involved in during the Arab Spring in Tunisia, but they, on the other hand, they have supported the opposition in Syria. Okay, so and then from this perspective, we are going to actually look into those. We are not going to only look into the actions of the states, we are going to look into the treaties behind those actions. So the last feature of the modern institution of international law is the discourse of institutional autonomy, right? So basically we said that we have three main institutions internally. That's the judicial, legal, and executive, or we call them powers. So in many historical periods, these three powers were either combined together under the name of, or let's say under the figure of the sovereign, or they were, or we can see that in the modern institution and modern legal system, we can see that they actually separate. Okay, so what does it mean? Basically, sometimes from the political perspective, the self-interest are considered legitimate if they actually respond to the national interest. But in the legal, from the legal perspective, or in the legal realm, the legal reasoning and argument will become the legitimate form of action. Okay, so basically, I would return back to the same idea over the similar case study of U.S. interventions after the 1990s. We could look into the U.S. intervention in Afghanistan from both political and legal perspectives, right? So from the political perspective, basically we said that the 9/11 actually undermined U.S. hegemony. From the legal perspective, we might want to have a look into some international treaties, and we might actually see that U.S. felt threatened, so they actually invoked an international coalition to arrange an intervention in Afghanistan as a protective measure, or as a counter-terrorist measure, in order to contain terrorism, right? So we should take into consideration two things when we are actually analyzing the discourse of the institutional autonomy, right? So we should actually consider the legal and political realms as separate and distinct in the modern phenomenon, and we should like interpret them. We should interpret the legal, executive, and judicial powers as separate powers, which cannot actually, let's say, which are not really interfering. So we could explain, for example, that where we discussed before that that a lot of scholars consider international law as a Western, as a product of the Western thought, right? So we could compare, for example, the why or different identities clash, right? So, for example, if we're going to speak about the clashes between Iran and U.S. from the perspective of constructivism, we would say that the identities are different for the simple reason that, for example, in U.S. Or in most of the Western states, legal, judicial, and executive powers are separate, right? So there is a lot of bargaining going on between these institutions in order to reach the final decision. Whereby in Iran, for example, these powers are actually not fully separate. Moreover, we cannot speak mostly about the secular law. It's more of the religious law, where basically the religious institutions are not separate or are interfering in the executive, legal, and judicial institutions. So that makes the final decision even more difficult, right? So the main idea is that the current discourse whereby the political and legal powers are in international relations are separate are actually ensuring that international order. Okay, So basically, from politically functional states will always ensure that the political, legislative, executive, and judicial powers are going to be always separate. Now, I want you to think about. I want you to return back to the to all the slides you watched so far, and I want you to reflect over different characteristics of the modern institution of international law, and which of them actually did not really raised in this chapter. So what we might do is you might return back to the globalization of world politics. You might want to browse through those through the list of literature I've given you at the very beginning of the slideshow. You might also want to have a look at the Joshua Goldstein's book and have a look how exactly the chapter of international law is discussed. And this is it for today. This is going to be uploaded on your MS Teams, and we are going to continue with the learning objective G5 and G6 in our further